TCPA compliance. She has been an integral part of PACE's current challenge to the FCC's TCPA order. Michele is an exceptional foundation in U.S. privacy laws and regulations and is accredited as both a certified information privacy professional through the International Association of Privacy Professionals and the Customer Engagement Compliance Professional, CECP, through PACE. Next, our other panelist today is Rich Goetz. Rich has spent his entire legal career in-house trying to keep his clients out of the courtroom and off the radar of class action plaintiffs and regulators. He has worked for sales companies engaged in direct-to-home sales and telemarketing directly and through channel partners, and even spent 5 summers in door-to-door sales as he paid his way through school. As a result, he has adopted a business-friendly approach to compliance by assessing real risk and not worrying about the hypothetical risks that will do little more than slow the business. Rich is a customer engagement compliance professional through PACE and also served as an instructor for other candidates going through the PACE CECP certification process. Rich has really been a help for us on this program and just did instruction last year at our Washington Summit and hopefully again this year. Rich and his beautiful wife and 4 amazing kids live in Heber City, Utah, where he loves to fly fish and cheer for the Utah Jazz. Now I'll turn the floor over to Rich and Michele.
Thanks, Stuart. And I'm really excited. Hi, Rich. How are you?
Good. How are you?
Good, good. And, I'm so excited about having Rich on our webinar today. I think this is such an important topic to understand the intersection between operations and the legal team, both inside of a company and then also external counsel. And Rich has just a wonderful history and wealth of experience in this area. So, Rich, we're really pleased to have you today, and thanks for being on our webinar today.
Thanks for having me.
The important part of what we're talking about today is that operations is really the front line for all of compliance, because operations sees, feels, hears, touches all of the issues that are involved with a company when they're working direct with consumers. And so if there is an issue, it is almost always known by the operations team before it's known by any legal counsel. And so if the operations team is armed with the types of things that, the types of issues that could lead to problems for a company, then they become a really integral part of the compliance network and also being able to prevent unnecessary risk in operations. So that's what we want to focus on today. We will give a background on some of the areas where we think, as Rich's bio pointed out, are the real risks and not necessarily the hypothetical risks, and how compliance and legal teams and the operations teams within a company can work to mitigate that type of risk. So with that, let's get started. I know that, the statistics that you see here on the screen for private enforcement, especially in the TCPA area, but also in other general consumer protection and telemarketing sales rule and state level, these are the types of numbers that we're talking about. So this is not an insignificant issue. We are looking at millions of dollars that are being awarded by courts on a weekly basis in areas involving compliance. And a lot of these cases, if you dig down to the root cause of the issues, had the operations teams and the compliance teams and the legal team been working more closely together, then a lot of these issues could have been mitigated in advance of the expensive TCPA litigation that they ended up being involved in. And so when we're looking at these types of issues, oftentimes the question is, whose job is this? Who's responsible for compliance? Is this something that is only a compliance officer's issue? Is it just a manager's issue on the call floor? Is it the seller liaison with contact centers and other advertisers? Who's really responsible for this? And the answer to that question is everybody is responsible. And that's why we want to talk about where those intersections are today during the webinar. we have general counsel that keeps the organization up to date on what the legal issues are. Frequently they're involved in education with the operations. They should be having regular meetings with operations, and so obviously they have significant involvement. Also, when we're looking at sellers or the marketers that sellers hire, the answer to who's responsible there is most frequently that both are responsible for compliance. And if a seller is engaging in operations with a contact center or other marketer and that seller or marketer is violating the law, we'll talk about how those types of things can lead to issues for the selling company. But ultimately, the responsibility rests with all of these individuals, all of these different business units, and it's really important that we work together on those types of things. A lot of the information that we're talking about today, I just wanted to also tell you, is an integral part of the CECP process, becoming an accredited compliance professional through PACE's CECP program. And what we're focusing on here today is the corporate compliance function. And if you are interested in learning more about this and being able to demonstrate your mastery of the topics that we're going to be talking about, then the CECP is probably something that you would want to look into more. As we talk about whose responsibility is it, and as we're talking about sellers and marketers in particular, then what we need to look at is some of the factors that the FCC has pointed out to us, and this came primarily through the Dish Network case. Dish Network engaged in sales campaigns through their independent distributors or their marketing partners, and they ran into some issues that have been very well documented over the years. And the FCC was asked to weigh in on the issue of when does a seller become responsible for its independent marketers' operations. And the factors that are outlined here are some of the things that the FCC pointed to when talking about third-party liability, and they premised it on this concept of common law agency. And while we could spend a whole day talking about just common law agency, these are high-level, the types of things that are important for our discussion today. First, the FCC pointed out that in addition to the agency theories, some of the types of things they considered important for assessing vicarious liability to sellers was whether the third-party marketing on their behalf had access to their information systems. So those internal seller IT systems and sales platforms, and whether those types of things that are generally only within the seller's exclusive control were made available to a marketing partner. If the answer to that question is yes, then that would tend to lead towards an analysis that would build on vicarious liability for the seller. Also, if that entity had access to directly enter information into those systems exclusive to the seller, that would as well. What did the seller do with regard to telemarketing scripts? Were they drafted specifically by the seller and provided to the third-party marketer? And then lastly, and this is a very important one and was in the Dish Network case, did the seller know that the third party's telemarketing violations were occurring and failed to take any type of steps within their power to address the conduct? And so that's one of those areas specifically where it's so important when you're understanding on an operational perspective that there are issues, that something be done about that immediately. So high level, I'll turn it over to Rich to talk about, from a general counsel perspective, how can you engage in mechanisms that would allow you to use a safe harbor in litigation if there, God forbid, should be issues with compliance by the company internally or any of its third-party agents? Rich?
Thanks, Michele. So kind of to dovetail on Michele's comment is ultimately who's responsible. In my experience, it ends up being whoever has the most money. It's usually the seller, and they usually become the target in litigation. And so when it comes to if you're the one responsible for the seller's operations or compliance, really a lot of the pressure falls on you to drive the compliance conversation with your third parties. A lot of times the third parties, whether it's a lead provider or a vendor, are less sophisticated. Some may not be as well versed in compliance, and so a lot of those responsibilities will fall to you. And when it comes to the safe harbor, this is an affirmative defense where you're basically put in a position saying, yes, there were problems, but we shouldn't be responsible because, and the federal law and certain state laws have these safe harbor laws where if you're doing certain things, you can actually be kind of let off the hook for technical violations. And so these are things that even if you're in a state that doesn't have a safe harbor, if you're doing these things, typically you're not the ones getting hauled off to court. You're not the ones that are stuck with massive liabilities, because you're not going to have massive liabilities if you're doing these things. So the first thing is to have written procedures, and we'll go into these in a little bit more detail on later slides, so I'll just go over kind of a high level. Written procedures, train your people, maintain and use an internal entity-specific do not call list. A big part of that is having agents disposition those requests, those do not call requests, so they need to be trained on how to do that. A lot of that is very automated now to make that very easy to have all of your campaigns suppressed with your do not call list, which is number 4, and then prove an error against written policies and procedures, and then monitor and enforce. So those are kind of from a high level, those are the different steps for the safe harbor requirement. And when it comes to the safe harbor, a big part of it is monitoring and enforcement. And Michele went through some of those factors on vicarious liability, but a lot of times when we're talking about monitoring and enforcement, we can talk about it internally if you're a first-party seller with your own call center, or you can talk about it in a vendor kind of oversight quality assurance program where you're overseeing the operations of a third party. A lot of the same principles apply. One of the big ones that's going to apply to third party oversight is, and those factors that Michele went through kind of speak to this, but it's the difference between having oversight but not control. And it is a little bit of a tricky balance where and courts have pretty consistently found that if you're controlling, if you're using a third party and you're basically dictating to them what they need to do, then you're going to be held vicariously liable for any mistakes that they make. But courts have also, on the other end of the spectrum, found that if you're doing nothing, like Dish Network, and you know that there are problems, but you don't want to step in, you're going to be held responsible for that too, because you knew that there was a problem and you didn't do anything about it. So it's a tricky balance trying to have enough policies and enough oversight without exerting control, and there are a few things that you can do to kind of strike that balance. Okay, so on the corporate governance side, every single one of these components is an essential component. Compliance guidelines, a big part of that is just making sure that everything is documented. I've seen companies all the time that will say, no, we don't do that. And that's about all that they can say, but they don't have any documentations of a policy saying that they don't do that, or even company guidelines or marketing guidelines or compliance code of conduct or anything that's documented. If you've got a policy or a common practice, that's great, but make sure that it's a written policy and it's documented. There's a big difference if you get sued. There's a big difference in being able to say we didn't do it and being able to prove we didn't do it. And so keep those things in mind, that documentation is a huge part of it. And from my experience, I think that's where a lot of companies are weak, is that even if they are compliant, they have a hard time proving that they were compliant. So that's a downfall for a lot of companies. The second one is training. And a big part of the training piece is making sure that all of the essential players, the key players for the different pieces, know their role and know where they fit into the grand scheme of the compliance program. So for example, you may not need to train frontline agents on the ins and outs of do not call scrubbing, but it's probably a good idea to make sure that they understand that on certain campaigns, we are scrubbing on the do not call list. And so when a customer says, why are you calling me? I'm on the do not call list, then an agent can speak intelligently to that and have the confidence to say, hey, we do everything we can within our power to make sure that we're calling only people who have requested a call, that we aren't calling people who didn't want us to call. I apologize for the inconvenience. Would you like me to place you on the do not call list? And that they can be more proactive and more educated so that they can take the wind out of the sails of those maybe serial plaintiffs who are trying to drum up a lawsuit against the company. And so the training for the front-end agent should be how to handle those types of situations if a customer starts saying, I never requested a call, or why are you calling me? I'm on the do not call list, or they raise a weird objection like, are you using an automated dialer? Those are strange objections, and agents should know how to handle those types of objections, but they're going to do a terrible job at it if no one's ever trained them on it. The worst thing that we can do from fending off serial plaintiffs is when they say, why are you calling me? I'm on the do not call list. If the agent's like, I don't know, your number was just the one that popped up on my screen. That's like blood in the water to the sharks, and we want to stay away from that. So training your people is really important. Next one is monitoring and enforcement. A big part of this is having a independent, whether it's a department or one person, depending on the size of the operation. It could be 20 people, but an independent quality assurance team that's looking for whether it's anomalies or whether it's violations or whether it's full campaigns that are non-compliant, that it's not the fox guarding the hen house. This is an independent quality assurance team who's looking for violations and figuring out what happened in these types of failures, and then having documented policies on, in the event an agent steps out of line, this is the process that we follow. We retrain. It's a verbal warning the first time, then it's a written warning, then it's a final warning, then it's termination, or having some type of point system. Any of those types of processes for remedial measures, but you have policies, you monitor for violations of those policies, and then you enforce those policies is an important piece of any compliance program. The next one is a critical path analysis, and this one is really, if you break it down in real simple terms, that's if this, then that. So if a customer calls in for the third time complaining that they're getting calls on the do not call list, what do you do about that? And a critical path analysis is one that has to be a lockdown process that is right every time, that there's very little room for failure, that everyone's trained on it, everyone knows what to do. These are ones that if it is they call it critical path because this is one we can't screw up. This is one we can't miss on. And so the critical path analysis is just having a game plan for different scenarios. If a customer says, I want to talk to someone in the legal department, or you'll be hearing from my lawyer, those types of things are probably good to know. What are we going to do to head that off before it picks up steam? Record keeping, we've talked about. A big part of that is saying that you didn't do something and being able to prove it is a massive, massive difference when it comes to litigation. And so just making sure that you're keeping track of all of those records, and not only just having a system that records everything, but also keeping it organized in a way that you can find it if and when you need it. A lot of that is labeling or working with your IT folks on how things are being stored. Once upon a time, I worked for a company that was putting everything on disks that took months literally months to get what we needed off of those disks when it came up in litigation. And so it doesn't do you a whole lot of good having it if it's a very timely and costly process to get access to those records. So work with your IT team and come up with a plan on how to store some of this information. And then legal guidance, have a good relationship with your legal counsel. The more you can get in front of them, and even your legal counsel, invite them to come in and do trainings with members of the team, whether it's a dial administrator, whether it's frontline agents, whether it's sales management, getting buy-in from sales. All of those meetings and those relationships are very important so that everyone feels like they're on the same team and the legal department's not out to get the sales team and just trying to make life difficult for them. Make sure that everyone's on the same team so you've got a good team dynamic there and you can work together. And then the last step is the compliance committee. The compliance committee is really important. I would recommend getting multiple people from multiple departments. It could be 3, it could be 5, it could be 7. Don't have it be an even number so it's not just always a stalemate. But get people from sales, get people from sales operations, get people from HR, legal, accounting, whatever you make sense for your business, but have high-level people who understand the business, what's good for the business, and can make decisions on certain compliance issues. Things like if a certain lead provider should be cut off for certain violations, if they've done good business for you for a long time and then they have one campaign that goes off the rails, be able to talk through those different factors and the risks and the pros and cons. But then that way you're protected because the compliance person's not the only one putting their name on something as saying, I made this decision and it's on me. Now it's a group of people with lots of different perspectives, lots of experience, and it insulates the company through what we call the business judgment rule, that businesses can make bad decisions. That's okay. But as long as those decisions are made in a well thought out manner. So,
Rich, probably a good time to mention PACE's self-regulatory organization. PACE has a set of standards that define what's required for a contact center to meet the state and federal regulatory requirements, but also best practices in the industry. And when going through that SRO process, you go through step by step all of those monitoring and enforcement type of steps that we were just discussing. It goes through each one of those critical components for a successful compliance program, and then you have a third party that's coming in and providing sign-off on that. The SRO is not the only way to do that. There are companies also that are members of PACE that provide those types of services, but having some type of system to come through and review that you're meeting all of these requirements, I think, is a very good idea for companies to minimize risk and to be able to sleep easy at night, knowing that they've checked all the right boxes.
Yep. No, it's a good point. And like what Michele was saying, it's not the safe harbor thing is nice, but companies that have those third parties coming in and they're going through this process and they're putting these types of things in place, the safe harbor almost becomes irrelevant because those are not companies that need to go to court and prove anything because they're compliant.
That's a great point.
So if we go to the next one, the monitoring and enforcement of vendors, a couple of important things. So we've talked a little bit about agency and not crossing the line into control when it comes to our third-party vendors. One of the things that's really important that courts have continuously said is okay is legal or compliance approvals. So while the seller doesn't want to be the one providing the scripts to a third party, because that starts to weigh more into your controlling what they're doing and you're going to have liability there. But what you can require is saying, hey, you guys come up with a script that you'd like to use and submit it to us for approval. And the legal department would go through it and edit the script for compliance concerns. And compliance the courts have consistently said that's not control. that's smart oversight, and that's okay. And so make sure that in all of your third-party vendor agreements, that when it comes to marketing materials or it comes to scripts or it comes to any of those types of campaign materials, that you're reserving the right, or not even reserving the right, but you're requiring that nothing can be used without legal department approval of the seller. Another thing, monitor vendor compliance to enforce company policies. So that's the same thing we talked about with having a QA department. It's the same that applies for third-party vendors. Just make sure someone's watching it and reporting any violations and making third parties report to those and be accountable to those. Periodic compliance reports, same kind of thing. It's not good enough to have a third party tell you, no, we're scrubbing the list. Oh, okay, that's fine, but we still need to get the report of the scrubs and how frequently you're doing that and which campaign you're doing it on and all of those types of things. And then a few things just to remind you of things that are good to put in your vendor contracts. Prohibiting or prohibition on subcontracting with any company without company approval. So this is an ADT lesson that we learned, is that ADT got sued under a vicarious liability claim for a dealer of a dealer that ADT wasn't even aware of. They were still held responsible for it because the court said that they should have known about it. And so, again, you can't just bury your head in the sand and say, well, that's not us, they're an independent third party, and think that you're not going to have any liability, because the courts have found that you should know who's representing you and who's out there selling on your behalf. And then, Michele, did you want to talk through the data audits?
Yeah, absolutely. So, I think one of the critical components for ensuring that your compliance programs are effectively functioning and they are preventing violations of the laws that would apply are using the actual data that your call centers, or if you're a seller, the call centers that you hire, produce during their calling campaigns. And doing a historical call analysis can reveal where there's gaps, where things have happened that, one, were not intended, or maybe two, the process hadn't effectively identified and taken steps to prevent. So some of the types of things that you'll want to be looking at when you're doing these data audits is, what type of systems are in place for DNC suppression, whether you're using a third-party provider or whether that's something that you're doing in-house. And just making sure that that system has fail-safes built into it and also has kind of the canary in the coal mine, so that if there's a problem, that you are finding that out very quickly before it becomes a very large problem. We're going to go through some case studies at the end of the presentation that will provide some factual scenarios where things went wrong and data audits assisted. So we'll give, like I said, specific examples then. Also, campaign management, also just so critical that as campaigns are being loaded, there's an understanding of what type of scrubbing has to happen for those campaigns. Are these campaigns where we have an existing business relationship, and so we're not required to do scrubbing except with our internal do not call list? But understanding specifically what that campaign is, what its attributes are, and that scrubbing is happening as it needs to happen. Compliance with the wireless rules. If you're engaging in sales calls, you're going to need prior express written consent to use an automatic dialer. So understanding what types of consent we have for our calling records, and then ensuring that we're complying appropriately with that. And then also call abandonment rates. Companies that are using predictive dialers are not allowed to abandon any calls, but there is a safe harbor that allows for call abandonment if you meet certain requirements, and that one of those is that it not exceed 3% over a campaign and over the course of 30 days. So that's one of those things that's very easily reviewed through a data audit. It's really important that these happen on a regular basis. It's not something that you can just do annually. I think a best practice would be monthly, but certainly no less frequently than quarterly. You are always going to want to make sure that you have SAN numbers that have been acquired and are current when you're scrubbing against those lists. So if you're downloading the national do not call list, or if it's the Canadian do not call list, state list, whatever those are, that you have a properly acquired SAN number. And then validating the DNC suppression is occurring. So through your quality monitoring and through these data audits, you're making sure that there aren't numbers that are showing up that were on the DNC list for which we didn't have an EBR exemption. And then most importantly, and Rich and I will stress this a number of times throughout this presentation, it only exists if you're able to document it. So you'll want to document those monthly audit results, and also if there's any remediation that's occurred as a result of those audits, you'll want to document those types of things. I will say that it's a good idea to work with legal counsel to determine if we would want to keep some type of attorney-client privilege around the data audits. We have companies that want to do that. We have other companies that don't believe that's a necessary thing, but that's something that if you're doing these types of data audits, you'll certainly want to consult with your internal or external counsel to make sure that the type of consent or the type of protections you'd need for attorney-client privilege were associated with that. Oh, Rich, did I skip a slide? Nope. And then as far as the results of any of those data audits, it's really important that there be some type of escalation plan. You wouldn't believe the number of companies that I have worked with over the many years that I've been practicing this type of law that there were problems that were identified just as they should have been identified, but unfortunately because there wasn't an escalation plan that specifically identified the types of problems that should be escalated and who they should be escalated to, that the proper escalation didn't happen, so the issue was never remediated. So it's really important that you not only have systems for identifying issues, but once those issues are identified, that you have appropriate escalation plans. It's really important, again, that you document how certain types of complaints or anomalies or maybe scrubbing areas or errors are handled. You have to have specific guidance on how those things should be, investigated, because not all of them are violations. Again, for instance, if you're doing a data audit and it shows that you called numbers that were on the do not call list, you could have an existing business relationship exemption that would allow that. So you've got to make sure that as part of the escalation process, they're identified. You also have to evaluate if processes need to be adjusted. If there was an issue that arose where a list was loaded improperly because we didn't have appropriate campaign management happening as the lists were being loaded, then maybe that's a process we need to look at again. Maybe there's an additional sign-off that needs to occur before campaigns are loaded or before they're initiated. And then once you do identify errors or anomalies, you have to let the right people within the company know that those occurred and what can be done to make sure that that doesn't happen in the future. The most important thing is we're identifying issues is that we make sure that they don't happen again in the future, so very, very important. Some of the things that are always going to want to be escalated, if we have irate consumers, it does always have to be escalated. Irate consumers are the ones that are ultimately going to lead to TCPA lawsuits being filed or complaints with regulators. And the sooner that we can handle those situations and make sure that the consumer's issues are addressed, the more likely that we can avoid those types of things. Repeated complaints, Rich has heard me frequently call consumer complaints a golden ticket, because if we have a consumer complaining about an issue, then, and especially if it's multiple complaints about the same issue, that's giving us this golden ticket from a compliance standpoint to look and say, okay, what is going on here that's leading to the complaints? It could be that we're not following the law, or it could be just the way that we're implementing processes and procedures aren't making sense to consumers, but it gives us the ability to look at those those types of things. And then if there is a failure of the compliance processes, then those are things that always have to be escalated. In describing an escalation process, I think this is pretty typical. The first level would be a manager. After that, maybe a compliance officer. And then depending upon how serious it is, or if we're getting repeated complaints in the same area, escalating to the C level to make sure that they have awareness of issues that are going on. Because most often, they are the group that will have the ability to make rapid changes in areas that are identified through this escalation process. Rich?
All right. So when developing a monitoring and enforcement task list, here's just a few of the items, few of the areas that make up an effective program. And so I've never seen a company that's perfect in all of them. Most of them have weaknesses, and some of that's specific to your business, the way that the business owners run it, or the way that the dynamics of the business, just the way that they are. Some things are going to be tougher in certain areas than others. And so I'd go through each of these in the checklist and just kind of evaluate. I think a good place to start on any of these things is seeing where we are now as a company and seeing where you might be a little bit light as far as what could be worked on. And as you go through the checklist, you can identify areas of weakness. But then I think it's important to put it into priority order, which is start with the largest risks that pose the biggest risks to the company, the biggest penalty amounts, the largest amount of exposure, and start with those areas first. So in today's world, this isn't even on here, but if you are doing pre-recorded messages, if you're robocalling people with pre-recorded messages, just from my perspective, I'd say stop. Just because there's so much heat and so much discussion from a legislative standpoint and regulator standpoint. Everyone hates them. Every consumer in America is mad about them. If you listen to the FCC and the FTC, they're talking about this as the highest complaint area. We have more illegal spam calls, blah, blah, blah. So even if you're doing pre-recorded message campaigns and you're doing them legally, you still have risk of being lumped in with the other robocallers that are sending pre-recorded messages to people. I would just you can do it legally and you can defend yourself in court. That doesn't mean you're not going to still have pressure, have liability, have to defend yourself in court if you get associated as an illegal campaign. There still may be risks there. Even though it's legal, there still may be risks. So that would be one. Look at pre-recorded messages first. Then look at things, calls and texts to numbers on the do not call list. Do not call violations are super easy to prove if you're a consumer, if you're someone complaining. There's lots of TCPA plaintiffs lawyers who have gotten really good, or even serial plaintiffs that have gotten really good at going after do not call complaints. So just make sure that your processes are buttoned up, that you're getting something like a trusted form if you are relying on some type of express consent to call a number on the do not call list. Make sure that that is documented, that consent is documented. I've always used trusted form just because it's a third party that you don't have to prove from an internal system standpoint that you didn't doctor the records after the fact or anything like that. You've got a certificate from a third party saying, here's the proof of consent, here's the time stamp, date stamp, the IP address, here's the picture of the screencast of the customer completing the form to give consent. All of those things matter, and there's a lot of technology and a lot of people out there that perform those types of services, so I'd say leverage them, and then it makes you sleep easier at night. Text is another hot issue right now, anything using an ATDS, so make sure that you understand what texting platform you're using. If there is a text campaign, it doesn't necessarily mean that it's illegal or it's bad, but just make sure that you are familiar with the rules, you know what type of platform you're using. Is this one that agents are manually entering in a message to a customer? to follow up to schedule an install. Well, that's a totally different thing than just blasting text customers for marketing purposes, trying to induce an inbound call. So prioritize those risks based on, consent management, based on the risks that it poses to the company, and start there and work down. Very rarely do you have a record-keeping issue if you didn't also have a do not call or a pre-recorded message issue. Record-keeping scripts, UDAP type violations are almost never what drives it in the first place. Those are usually tack-on offenses because it is just so easy to find violations in the pre-recorded message, text, and do not call areas that they almost always start there, and then regulators or plaintiffs or whoever will just dig in deeper and see what other problems you have if you've got problems in those major areas. So prioritize your time appropriately. Don't spend a bunch of time making sure your record keeping is where it needs to be if you've got a bunch of non-compliant campaigns that are texting customers without the proper consent. Sample monitoring guidelines. So these are just some ideas, and I don't know, Michele, do we end up sending this this slideshow out to everyone?
It's available on the PACE website to members after the presentation, so they'll have access to it. Yes.
Okay. So some of these are just kind of samples of things that I'll just let you look at those later to give you some ideas. Again, data, I think Michele and I have both kind of talked about this, is data is a valuable compliance tool. It tells the story, and it also can direct your efforts on where you're weak and where you need to focus and spend your energy to protect the company. And then the compliance monitoring program structure, we've talked about these in some detail. Perform compliance certification of all marketing partners. So this is just kind of a starting point, is see where you are now and review all the marketing partners, all their materials, identify high risks, and then start chipping away at it. Number 2, perform regular data audits on campaigns. So once you've done kind of an initial review, then get some type of cadence together for regular data audits so that you can continue to monitor them. Perform data analysis to determine if any communications were suspect. So same type of thing, you're just using the data to point you to areas that might cause problems. Work directly with marketing partners to identify and correct issues. That's part of the monitoring and enforcement. If you do find issues, you've got a plan in place to help correct those issues. Some of that can be through contracts, some of it can be through guidelines, and others could be, hey, we've had this specific problem, we need it fixed. And then provide detailed records of due diligence and efforts to comply. So document everything. Those are the things that matter. Just saying we had a conversation isn't good enough. Make sure it's documented. Make sure you've put everything in writing. If you have a phone call and you're correcting a partner over the phone, follow it up with an email saying, hey, just wanted to follow up on our phone conversation, and this is what we talked about, just to make sure that it's documented. Michele, case studies.
Yeah. So, you know what? You can do everything perfect. You can have the processes and procedures in place, and you can have oversight. You can do all the types of things that Rich has been talking about for an effective compliance program. But, you know, again, stressing the importance of going through and auditing to make sure that all of these processes and procedures that we have in place are working. And frequently that's done through data audits that we've talked about. And here are some examples where data audits have identified issues and remediated those issues before they either became systemic or became such a large issue that they were difficult to take care of. For instance, a vendor uploaded 11 months worth of internal DNC records at the end of the year. And as a result, vendors were dialing consumers on sellers' internal do not call list. And so obviously a big problem when a consumer has specifically told you that they don't want you to call them, and then they start getting calls, that becomes a big issue. If we're doing data audits, we can identify through our call records whether the folks that we've called are on our internal do not call list. If we're doing this on a monthly basis, it's going to identify this issue quickly and allow us to remediate it. And if unfortunately we were to get into any type of problems, then this is when we're going to rely on the safe harbor that we've worked so hard to put together with our compliance, written policies and procedures, training, monitoring, and then identifying an anomaly like this. Also, a situation where a vendor was receiving just single EBR flags for campaigns, and instead of those being suppressed, the way that this system ran, if the phone number was also on the state or national do not call lists for EBR campaigns, then it was not being suppressed. So an issue that was identified quickly. If the vendor has a database that they're relying on to do their scrubbing of DNC records, as what happened here, and that system crashed, then those DNC scrubs are not going to occur. So going through the data audit would allow us to identify those types of things. And then a vendor was calling a specific city and was using their EBR data for that. But unfortunately, they included states' phone numbers that were not being scrubbed during this campaign. It resulted over 1,000 calls being made to DNC numbers. So being able to identify these types of things is the purpose that we're, or the end result we're looking for, is that if we do have an issue, it becomes a one-off issue, and it doesn't become something that is systemic or something that we are not going to be able to remediate. Just graphically shown through a flow chart, these are how data audits occur. It says vendor submits data here. It could also be seller submits data. We're assuming here a situation where a seller is requiring a vendor to go through these processes. The files are then run through the audit process. So, what is it that we intended to happen here? Are we running through EBR records? Are we running through what should have been suppressed through one of our DNC lists? But it will be run through the appropriate process. Issues are identified. Typically what you would then want to do is have the ability to do research on those issues and offer an explanation if there is one. It could be that there was a good reason these were called, and maybe the EBR flags were not showing up initially during the audit, and so while it may have appeared that we violated do not call rules, we had an exception to the DNC requirements. Frequently, if you're going through a more formal process, audit letters will be created and sent to whoever is involved, if it's a seller here, if it's the compliance department, something of that nature. But then most importantly, what happens is at the end is when we've gone through this audit process, if issues are identified, it gives the company the ability to remediate those issues and make sure that they don't occur in the future. As part of the SRO program that I've mentioned, quarterly data audits are done with the companies that are SRO accredited, and so the companies, just by virtue of going through the SRO, have the ability to go through these audit processes and receive those types of benefits. Here's a summary that you would receive if there were issues. And typically, we're looking at suppressing calls that are on the national do not call registry or state registry, or if they're wireless and we're using an automated dialer and don't have the appropriate type of consent. And then also, obviously, importantly, scrubbing against the internal DNC list. So this would be an example of what a seller's summary of audits could look like for various vendors that they're using. And as you can see, the eCenter, it would look like would potentially have some issues, especially if we're talking about an acquisition campaign. Probably unlikely that we would have DNC there. So this would be an example of when an audit program is going to pay off and potentially identifying issues with a vendor. The South Center This shows that there may have been some issues that were involved in their campaigns. That's one where we would want to allow the center to explain why there were 162 calls that occurred to numbers that are on the national do not call list. But obviously knowledge is power, and with this type of information you can determine if there are issues and then work to remediate them. What has been demonstrated through going through these types of audits is that the issues that occur throughout the years significantly reduce. So statistically it has been brought out that these types of audits assist in making sure that there aren't issues in the future. Just the same type of thing on the abandoned call audit report. So with that, Rich, I think we're wrapping up here, and I think we're actually going to do it on time. We have 6 minutes for a couple of slides here. Rich, I think you might be on mute.
Well, I was just wondering if we were going to get any questions, but one thing
maybe we stop here.
Oh,
go ahead.
Well, maybe people can type in their questions, and while they're doing it, I'll just tell one more story. That another thing that, especially if it's a first-party call center, it's your own call center, make sure the people know you. If you're the compliance person over those types of campaigns or all the campaigns, make sure that the individual frontline agents know who you are, that they see you, whether it's you going into new hire training when they're bringing on new agents and introducing yourself and doing some training or whatever process you can do, is get in front of the people, and it will pay huge dividends. And I had an experience where we had an agent that called me and was saying, hey, I just got a weird call. It was an inbound agent supposed to be taking inbound calls. He said, I just got a weird call. I did the script. Thanks for calling. What has you calling in today? And their person's response was, I didn't call you. You called me. Because it was so weird. And so it almost immediately triggered, okay, we need to shut off this lead provider and figure out what's going on. Luckily, we were able to catch it very early, but it was a lead provider that, you know, quote unquote, accidentally turned on a pre-recorded message campaign, a press one campaign that was against our contract. It was a breach of contract, but we identified that very quickly, and we were able to shut it off before it became a major problem for us. And so that never would have happened if I wouldn't have had a good relationship with a frontline agent who knew if there's something weird like that, I can just pick up the phone and call Rich. And so if they don't know who you are as a compliance person, you're never going to get that call. And so that's just one little tidbit, is just make sure that you're visible. Don't lock yourself in your office and just looking at the data too. Be out and about and have compliance be part of the culture of your call center. And if everyone is out there keeping their eyes and ears open for issues, then you'll be much better off than trying to do it all yourself.
Great advice. Great advice. Are there any questions out there at this point? Although I think Rich has so thoroughly described how compliance and operations intersect, I can understand how there wouldn't be any questions.
Or I think everyone's asleep. It's time to wake them up.
Not possible. Not possible.
Is that the last slide, Michele?
Yeah, that's where we're getting. Yes.
Oh, there's your contact information if anybody wants to talk to either Michele or Rich. Well, there's no other question. Go ahead, Michele.
I would just say, you know, as a benefit of being a PACE member, you have the ability to call our general counsel office and ask questions that are general. We can't give specific legal advice, but I frequently get calls from PACE members just saying, hey, you know, I understand there's a new law in Nebraska, let's just say, and is that true? And I can say, yes, there is a new law in Nebraska, and we can send that to you. So, you know, those are questions that we're always happy to respond to.
Just a couple things. So the actual whole recording of the webinar will be online on the website in a couple days. But as I said earlier, if you want the slides, you can email me and I can actually send you the PowerPoint today. Because considering we're all involved in compliance probably on this call, our Washington Summit is the 22nd and 24th at the Intercontinental on the Wharf in Washington, D.C. Early bird registration is open, and we have some exciting possibilities of speakers coming to us in Washington. We also, our next live events, we have a day-long regional event in Akron, Ohio on Thursday, May 16th. And this event is the third in a series of regional events that combine, that encompass topics on compliance and operations. And actually, Michele, you'll be there on May 16th.
I'm looking forward to it.
And information about the event and registrations on the website. This is at the Taylor Institute for Direct Marketing at the University of Akron, where PACE, well, actually ATA, had a really was a big help in the starting of that curriculum there. And don't forget, if you're, check out all the other membership opportunities on our website, depending on what level of membership you are. We have our benchmark portal operational courses and certificates, our online resource directory if you want to get your brand out there, and sign up as many people from your organizations as affiliate members, and they are also entitled to all the content that PACE provides. I want to thank Michele and Rich for this and for everyone participating, and we'll see you hopefully soon, maybe in Akron.
Have a great
2
day.
o'clock, exactly. 2 o'clock exactly. Look at that. Thanks, everybody.
Thanks, Rich.
Thank you.